think this case...
So you're saying there is no other remedy?
I don't think there, I mean, I don't think it would be, I think it's reasonable that she's exhausted all her remedies in Connecticut, given that if she initiated another petition, it would get transferred there and would again involve the Connecticut Assistant Attorney General's office, who's already dropped the ball twice.
What about the child? Would the child have the ability to sue in the child's own name?
Well, there is, under the Family Court Act, there is a provision that says the child can sue, but I think that wouldn't make the case any easier, because the court would still be confronted with the question, should we give full faith and credit to the Connecticut judgment?
There would be serious questions about privity, whether the mother was the champion of the child's interests. Their interests were so similar that the mothers could have been expected to pursue the support obligation with such vigor as to preclude the child.
That's right. In addition to the regular questions of whether to accord full faith and credit, there would also be the additional layer of the privity question, and I think you'd have to look to Connecticut law. Is the mother in privity with the child? So that wouldn't simplify anything to bring a proceeding.
So going to your fallback position, which is that Connecticut would not accord this judgment preclusive effect, and therefore we don't have to. What's your best case? Would you concede there's no case actually in point in terms of a dismissal of a paternity proceeding because of the failure to do a blood test? Is there? In terms of
not that I've been able to discover, but the two, I guess my two Connecticut best cases would be Milgram versus DeLuca and Ruddock versus Burroughs, where the Connecticut Supreme Court discussed these disciplinary dismissals and that they are not considered to be on the merits.
Can we ask Connecticut what Connecticut thinks?
Well, this court did ask Connecticut to appear as amicus curiae, and they're not here defending their interests. I mean, they could be defending their judgments and the strong interest in the state sovereignty, but they're not here.
But Judge Rosenblatt's question is, can we ask the Connecticut courts to tell us here, in a situation where there is no case actually directly in point, could we do that as an alternative?
You could, Your Honors, although I think these two cases that I've cited to you do support the position that it's not an on-the-merits dismissal under Connecticut law. But courts routinely look at other courts' law to determine whether to give full faith and credit to a different state, so I don't think that's necessary.
Thank you. Mr. Olch?
May it please the court, just introduce Mr. Harry Burstein, who is attorney of record on the case. I think one principal point, there's no question in this case that the Connecticut court had in personam and subject matter jurisdiction, and that ordinarily should be the end of the inquiry. The appellant, however, has raised the question of due process, and I think, unfortunately, it's rather vague.
Well, there's a third leg there before you get to full faith and credit, which is that the state of Connecticut itself would give res judicata effect to the judgment. And
in this case, we have demonstrated on the record that, in fact, it did. Your Honors will recall that a second petition was instituted on behalf of the petitioner in 1997. It was filed with the Connecticut courts. The same exact Attorney General appeared before the courts, and the transcripts of that have been submitted to the court by the appellant, and that proceeding was dismissed on res judicata grounds. And in fact, the Attorney General of the state of Connecticut said that since there had been no appeal from the first one under Connecticut law, the first judgment stands.
Well, there, of course, had been an appeal, Mr. Olds, but there had been an appeal, but that very same Attorney General did nothing. Nothing to protect the rights of this child and her mother, where the statistical probability that he is not the father is 3 in 10,000. So why should this court give full faith and credit to a fingerprint identification of a man who's the father of the child when the Attorney General of the state of Connecticut did nothing to appeal that matter, to determine as a matter of law by an appellate court whether this had preclusive effect or not?
I think there are two answers to that. One, if there has been an error, the error has occurred in the state of Connecticut, not in the state of New York.
You mean the error as to the preclusive effect or the error as to abandoning the appeal?
Well, I'm not conceding it was abandoned. I'll come to that second. Assuming arguendo something was abandoned in Connecticut, if it was abandoned in Connecticut, that has to be corrected under full faith and credit by Connecticut. This is not the Court of Appeals of Connecticut, and that has to be addressed by the Connecticut courts.
Was this youngster entitled to effective assistance of counsel in Connecticut?
Well, it's not clear, frankly, whether the law has been extended to cover civil litigation. Under the
paternity is recognized as a fundamental right, is it not?
Yes. Yeah, well, I think it is, but
at least for equal protection purposes.
Equal protection purposes.
Why wouldn't it be for due process purposes?
It may well be, because certainly...
And then just following along with that, if it is a fundamental right for due process purposes, then wouldn't this youngster be entirely effective assistance of counsel?
I think the answer is not that. I think two answers to that. One is I don't think the standard in criminal cases is readily transferable to civil cases. And secondly, even if...
Well, this would be just plain malpractice, wouldn't it?
Well, no, I would not concede that there was malpractice. I think the attorney did everything he could do with the hand he was dealt. When he learned of the mistake, he immediately made a motion for a hearing, whereas I think one member of the court pointed out, he laid this all out to the Connecticut court. The Connecticut
There was
court
no
did not make
appellate remedy?
Excuse me?
There was no appellate remedy?
Well, what he then did, what the record shows, and he did this under Section 231 of the statute. There's a specific statute that Connecticut has, which is Section 46B-231, which is the statute that sets up this division of the Superior Court, something like our family court. And what he did is he filed an appeal within 14 days, as the statute requires, to the Superior Court. It's not clear to me whether that court sits with just one judge or a panel. He filed the appropriate papers, and what the record shows is that the appeal was, I guess, in our terminology, was never perfected.
Who would have had the obligation to perfect it?
It would appear, frankly, to be the Attorney General, but what we don't know from that...
So we're still talking about the same person who goofed.
Well, we're talking about the same person, but the assumption, I think, of the questions is that he somehow defaulted. What we don't know from this is whether he made a decision on the merits that this appeal would be unsuccessful under Connecticut law, because I do not accept that appeals with prejudice are simply never imposed in the state of Connecticut. The Connecticut decision referred to by my adversary indicates that, in fact, these are done on a case-by-case situation. And, in fact, the dissenting judge in Connecticut complained that what was happening was that clients would be blamed for the default of their attorneys. But the majority view was different. So I would not agree that there was a default. We don't know why he didn't pursue it. We do know that 2 years later he again tried a second time. So I would not say that he did not provide what, under criminal cases, would be meaningful representation.
Well, can I take you back to, Mr. Olds, to your assertion that the AG played the hand that was dealt to him. Now, you as a counselor, you're representing these New York folks, and there's a report through a court agency, a Connecticut court agency, that your clients did not comply with the order to do a blood test. What would you, as a professional, a highly trained and highly ethical and able professional, do at that point?
Well, two things. One is...
Would you possibly have tried to get a hold of your client to find out whether that's happened, or to advise that you better comply with this order because you're in danger of losing this case preclusively? Would you have done that as a professional?
I think the answer to that is yes, and I think that's exactly what the attorney did. I point out that...
Is there something in the record about that?
Yes. What happened is that on July 10th, 1995, when the matter appeared before the court, after the judge dismissed the case with prejudice over the Attorney General's protest, the Attorney General saw a woman sitting in the courtroom. He conferred with, and that turned out to be the woman involved in this case. And she told him there had been the blood test. He then immediately, as a good ethical attorney would do, filed a motion with the court for rehearing.
Well, I'm looking at May 9th.
Yes.
Which is 2 months earlier.
That's correct. Nothing happened on
Excuse me. May 9th.
Right.
The SED advised everybody that there had been a non-compliance with the order to do the blood test. Now, I'm putting you into the shoes of that Attorney General who just heard this news, And what would you have done at that point?
Well, Connecticut, I might add, Connecticut is not, this is not a judicial branch. As that Section 231 points out, the Department of Social Services and the woman who appeared, Ms. Dawson, is a member of the executive branch of Connecticut. It's not a court agency, but I don't think
Anyway,
that's
whatever hat they're wearing, there's the advice from the agency.
I think they did exactly what they should be expected to do. The case first appeared on the calendar on April 3rd. The judge said, if this is not resolved by July 10th, I'm going to dismiss it. The case then appeared on May 9th, and there was no report back. They did what they were supposed to do, and apparently New York was notified because they sent back an indication of at least 2 of the people had taken the blood test. That information, as I understand the record, was not conveyed to the Attorney General on July 10th as he stood in the courtroom. But as soon as he learned of that information, he did the appropriate thing.
So you would have just passively waited for another, for this agency to go ahead and verify one way or another. You wouldn't have done anything on your own on May 9th to ensure that your client would be prejudiced by failing to take the blood test.
They did do what they were supposed to do because New York did have the blood test conducted. What apparently was wrong is they did notify New York, and the transmittal from New York back to Connecticut somehow was misplaced or mislaid in the Connecticut office. But as soon as he learned of that, he did, and he laid it all out to the Connecticut judge. The Connecticut judge on August 14th, every fact to which this court is now privy, he was privy to. He determined he would not change the nature of his ruling. Now, that may be a mistake under Connecticut law, it may be an abuse of discretion under Connecticut law, but it is Connecticut law, and this court is not an appeals court for Connecticut.
Mr. Olds, there's no indication in the record that anyone in Connecticut in the judiciary took a look at the merits of this case, is there?
Not the merits in terms of the evidentiary merits. That is correct. That is correct.
These are all...
And indeed, at that time, there were no blood tests to take a look at it. Indeed, the blood tests in New York actually came in after the rulings in the lower courts. They came in while the matter was in the appellate division. But no one looked at the merits. But I don't believe that's dispositive. As the Supreme Court said in the Logan case, to which counsel refers, you don't have a due process right to a trial. Courts can, in fact, dismiss cases on procedural grounds if you don't meet their time limit. Statute of limitations, I guess, would be a classic example. Other time limits set by judges.
What's the best case where they've done that in terms of a child and paternity and...
I don't know if there is a best case, but I certainly do not believe that the full faith that there is a public policy or childhood exception to full faith and credit. And I think that the United States, as harsh as that may be, I think the Supreme Court has made very clear that full faith and credit is a very exacting, demanding, and at times perhaps inequitable result. But that, they have said, is the price
Don't we have
to pay.
a public policy that the interest of the child, regardless of a custody determination, let's say, in one state can always be raised in another state?
No, custody determinations now, based on the federal statute, are accorded full faith and credit. In fact, this case would be one of the few situations, as I understand, as I put in my brief, the trend in the law, both in custody disputes, financial laws, and so forth, the trend in the law is to afford full faith and credit to
but
the child.
But if there's a showing of changed circumstances, or that the best interest of the child would be served by a change in custody, let's say, or a change in a visitation.
Then one goes back to the court which rendered the judgment. The whole point of all of this...
But if the child is living in a jurisdiction, in another jurisdiction, let's say it's been there over 6 months, a year, can't that second jurisdiction assume?
It's my understanding under the uniform statutes, one must go back to the court in order to prevent this sort of child napping or kidnapping situation. One must go back. But this is not a changed circumstance situation. This is a situation of a judgment which has been rendered by a court of competent jurisdiction. One can argue with the merits of that determination, and the fact that a child is involved is a factor. But I also do not agree with my adversary that there's no other recourse for the child.
The judgment was basically based on the fact that there was a failure to comply with the judicial direction.
Yes, New York courts dismiss cases all the time because our appellate divisions will dismiss with prejudice any appeal not perfected within a certain period of time. Courts constantly dismiss cases on procedural grounds. It's
Why isn't that a failure to...
What is the recourse?
For
the child.
For the child. The recourse for the child, and I am not the child's attorney, but certainly this issue was raised in the family court, and it was raised again in the oral argument before the appellate division. The first family court decision, the judge says the child should bring an action in her own name, and that is permitted under the family court. Now, in the state of New York, there is a division among the appellate divisions. as to whether or not the child is sufficiently in privity with the mother or not. I believe this court has not passed on that question.
Do you doubt for a minute that your side would